my name is Leo Yu. I'm the former chair for the ACSDFW chapter. I'm also a senior city attorney for the city of Dallas. Before we start, I would like to introduce our three panelists. First, we have Joe Page. Joe is the chief of the appellate division of the Federal Public Defender's Office for the Northern District of Texas. He has written over 1,000 briefs to the Fifth Circuit and helped write brief 4 times of FPD's cases that go into the Supreme Court. For the past 10 years, he has witnessed the evolution of the Fifth Circuit and the Supreme Court's jurisprudence regarding criminal history enhancement and helped obtain appellate relief for numerous defendants. And thank you, Joe.
Thank you.
Next, we have Tracy Pearl. Tracy is a law professor at the University of Oklahoma. She is a nationally recognized scholar on emerging technology and the law. She researches and writes about risk, regulation, and criminal law in the areas of driverless vehicles, drones, the Internet of Things, and other new forms of technology. Her scholarship also explores whether and how procedural rules impact due process and how courts treat novel societal issues. Thank you, Tracy, for joining us. And then we have Brandon Beck. Brandon is an appellate attorney with the Office of the Federal Public Defender's Office for the Northern District of Texas, and he is also a part-time professor of the legal practice at Texas Tech. He's an active appellate attorney who has argued more than a dozen cases before the Supreme Court, before the Fifth Circuit. And in 2019, he argued and won the case of the United States versus Davis before the Supreme Court. Good for you. He frequently writes and lectures on federal criminal law, constitutional law, legal history, and contemporary issues in criminal justice. Thank you, everybody, for joining us. So I think we all agree that in the past 2-3 months, the biggest event at the Supreme Court is, unfortunately, is RBG's departure from us. We heard a lot of, comments and discussions about her legacy in women's rights, or really in civil rights in general. But what I haven't heard a lot about is her legacy in criminal law. So that's my first question. So what is RBG's legacy in the area of criminal law? And I would start with Joe.
Yeah, I mean, I think that it's the loss of Ginsburg, and her replacement is, by any way you measure it, a very, very hard blow to criminal defendants and to other people that are caught in the subjected to the criminal justice system. I think that if you look at her majority opinions, the ones that she wrote, all of the ones that she wrote in the course of her career, and that may not be completely representative of her legacy, that, sometimes a vote is more important than the opinions that you write. It does sort of strike me that she was not equivalent for criminal defendants to a Justice Marshall or a Justice Brennan, who were just absolutely unshakable votes for criminal defendants. I can think of, maybe 2 cases where Justice Marshall ever sided with the prosecution, and one of them was United States versus Nixon. So, I would just to back up, to have a sense of check my own intuitions about this. I went and looked and counted how many of the opinions that she wrote were for each side. And of course, that's an imperfect measure. Doesn't tell you how she voted or wrote in the most important cases. And of course, sometimes you might switch sides to write a narrower opinion. There's strategic reasons you might write differently than you might vote. But about 60% of the time, she was writing opinions that were favorable to criminal defendants, and 40% of the time for roughly to the prosecution. And I don't think that you would. I didn't run the math, but I don't think you would get anything like that if you compared her to the generation of liberals on the court, Marshall, Brennan, that were before that. If you looked at that, you might get something more than your intuition. But so I think that you have to see her legacy as a lot more pragmatic, and that she was a very strong voice for criminal defendants, but that she was by no means an unshakable vote, and that sometimes she was probably behaving strategically to narrow an opinion. What I can't think of here is, in all of her time, more than one case in which she supplied the fifth vote for the prosecution in an important area of criminal law. I think that she's sort of like Justice Kagan is now, in that you weren't always assured of her vote, but it was almost impossible to put together a coalition without her.
We're going to talk about Kagan just a little bit later, but Tracy, what do you think?
Yeah, I agree with everything Joel just said. When I think about Justice Ginsburg legacy in criminal law and criminal procedure, I think about fairness and transparency, really. Those are sort of the two buzzwords that come to mind. She always struck me as somebody who was deeply opposed to things like gotcha sentencing enhancements, cutesy procedural and technical tricks that the government might try to employ, and any other sort of, interpretations of law that would dramatically ease the burden of the government. And so, I think she was a very reliable vote in those kinds of cases. I wish she had been a more vocal champion of prisoners' rights. I wish she had been a more vocal opponent of the death penalty. But, she did some important work by way of voting in terms of sentencing reform. She was an important vote in some of the children's rights cases in and around death penalty and sentencing. And so, to that extent, I'm grateful for the work that she did.
Brandon?
Yeah, I'd just like to kind of jump off of something both Joel and Tracy said. Joel talks about Marshall and Brennan and how she really isn't quite in that camp. I would actually also add Justice Sotomayor to that camp. I think she kind of is the modern legacy of Marshall and Brennan. Justice Ginsburg didn't write majority opinions on the big watershed criminal cases. When I went back and looked at some of her more recent cases where she wrote the majority opinion, cases like Kimbrough, in cases just this last term, Schuler versus United States, they tended to be very technical sentencing law cases, nothing that's going to make a big headline. I think the most recent case of hers that would kind of fall into more of the traditional law school criminal procedure case would be Rodriguez versus United States from 2015, which was actually a case I've used quite a bit in my own practice, dealing with the duration of police stops and whether that becomes an unconstitutional seizure. So, not a guaranteed vote. In fact, when I was preparing to argue United States versus Davis, one of the cases I was most worried about being used against me is a case called United States versus Hayes, which was a Ginsburg opinion that I thought to an extent damaged my argument. I think the government didn't do a good enough job of leveraging that argument. Ultimately, though, I was able to get Justice Ginsburg's vote. I did want to add one other thing that I think, is an important part of her legacy before she was a judge, but really is carried over as a judge. And it's the fact that she was an advocate. And she was not only an advocate, she was an advocate for individuals who were in a system of oppression. And I don't think you can ever forget that when you move over into the bench. And that's something that we don't really have. I mean, Roberts argued 39 cases, mostly for corporations, I assume. Justice Kagan was an advocate, but as a solicitor general. But Ginsburg represented individuals. And I don't know anyone else on the court, and I may be wrong, that did that. And I think that gave her an important perspective that is easily lost. So I just wanted to add that as well.
That's a great point, Brandon. Oh, for our attendees, by the way, if you have any questions, feel free to use the Q&A function. I'll try my best to answer your question with our panelists at the end of this session.
To agree with Brandon and Tracy both, just to chime in one more if we have time, I think that one of the real losses that we'll have with her is habeas. That the rights of habeas petitioners to challenge unlawful sentences, assert claims of actual innocence. She was absolutely a steadfast champion against procedural technicalities that would keep people out of court from asserting rights long after sentences had begun. And that I think that really speaks to what Brandon was talking about, and also to what Tracy was talking about.
So let's move on to a case that has been decided in the last term. The first one I would like to introduce is Ramos versus Louisiana. So Brandon, why don't you tell us something about this Ramos, about this very interesting Sixth Amendment case?
Well, I think Ramos last term, probably tied with McGirt versus Oklahoma, is one of the most interesting cases in terms of its implications. The question presented in the holding was actually very simple. The question was simply, well, you had a situation where both Louisiana, the state of Louisiana, and the state of Oregon had this non-unanimous jury rule where the state could secure a conviction in a jury trial when only 10 out of the 12 jurors believed the defendant was guilty. So the question presented was simply, does the Sixth Amendment, as incorporated into the states through the 14th Amendment, require a unanimous jury in order to secure a conviction? Ultimately, the court held, yes, it does. Justice Gorsuch wrote the plurality opinion, which is considered the controlling opinion, did kind of an originalist look back at the history of this question, starting in 14th century England, looking at what the state of the law was at the time the Constitution was written, and then kind of moving in and trying to figure out where did this come from. And in fact, unsurprisingly, it came from a time of racial prejudice and racial strife. Louisiana, as part of a state constitutional convention, put into place this non-unanimous jury rule in 1898 in order to water down the votes of African-American jurors. Oregon did something very similar in 1930. So, but here's where it gets a little bit more interesting. The problem with it was back in 1972, in a case called Apodaca, the Supreme Court had considered this very question before and held in a plurality opinion 4-1-4 that these laws were indeed constitutional. So there was a precedent. There was the stare decisis issue that the dissents relied upon in Ramos. But what was interesting about it is you had 4 justices who believed the law was fine, 4 believed it was unconstitutional, and then Justice Powell had this one justice concurrence. And it was in that concurrence where he said, I think the Sixth Amendment requires a unanimous jury. I just don't think the Sixth Amendment is incorporated into the states in its fullest form, because he believed in this dual track theory of incorporation, which has since been rejected. But the question became, and this is where it becomes more interesting and has greater implications today, under the rule of Marx versus United States, where you take the narrowest holding in a plurality, do we really give that to a one justice concurrence when the justice is basing its his or her concurrence on an idiosyncratic view of the law? Gorsuch rejected that, said Apodaca doesn't have that same form of precedent because of the nature of that concurrence, and reached the conclusion. And just to a talking point, one more minute, we're seeing this playing out in really interesting ways now in the abortion cases, where you have the most recent case, June Medical Services versus Russo, plurality opinion. Roberts writes a one justice concurrence saying, I think it's wrongly decided, but I think precedent requires it. And now you have circuits that are saying effectively that Roberts overturned the rule in Casey. In fact, the Fifth Circuit is taking that issue up en banc based on Judge Willett's dissent in a case called Whole Women's Health versus Paxton. So fascinating kind of reevaluation of this doctrine, Marx versus United States, where the narrow is holding controls, and people are saying, wait a minute, let's see how that plays out. So I know that's kind of a long description, but there's a lot of interesting implications about Ramos, even though the holding is very simple.
So Joe, let me ask you this. I think the 6 arguments based on the 6 amendments sound like they have an easier route in the Supreme Court compared to the 8th, the 4th, or even the 14th. So why do you think the 6th Amendment is something that is able to occasionally glue liberals and conservatives together to form an opinion?
Yeah, that's a great question. I think that there is some evidence for that. The Apprendi line, the line of cases beginning Apprendi through Apprendi versus New Jersey and continuing, all the way to the invalidation of mandatory minimums based on judicial fact finding. The cases that involve a jury trial right, there has been a very strong coalition or a sturdy coalition of liberal and conservative justices that have been able to count to five on a lot of cases involving jury trial rights in areas where there haven't been that kind of coalition or support in other areas of the law. And the Occam's razor theory, I think, is just that the historical record is pretty good about the right to a jury trial, so it might be very attractive to originalists. I mean, frankly, if you read some of Scalia's writings about it, United States versus Gowden, and even some of what they've written in Apprendi, they're fairly close to saying that there's a constitutional right to nullification, to jury nullification. And so you can imagine they haven't said anything like that, but I mean, that's not part of the holding, but given that if originalists think that is sort of the baseline of what the right to a jury trial meant at founding, you can imagine that you might have a lot more success trying to sell applications of the right to a jury. You compare that to, say, Eighth Amendment claims, which seem to be, coded into our political discourse as cultural issues of culture war, the death penalty, life without imprisonment for juveniles, and that really, the coalition really starts to break down.
We're definitely going to talk about that Eighth Amendment issue at drones later. But Tracy, what do you think? Why do you think the Sixth Amendment now is kind of like the lucky amendment when it comes to criminal issues?
I have sort of a more practical view. I teach criminal procedure, and on the very first day, I tell my students that it's going to take 2.5 months for us to cover the Fourth Amendment. It's going to take 2.5 weeks for us to cover Miranda and the Fifth Amendment. And it's going to take us 2 days to cover the Sixth Amendment. And that's largely because the Sixth Amendment is so much less convoluted and has avoided, I think, the complexity, and some might say the difficulty that's been inserted into the jurisprudence for the other two amendments. It's a more straightforward amendment, at least jurisprudentially. And so I think there's sort of less gamesmanship that can happen in and around the Sixth Amendment, a way that there just isn't with regard to the Fourth. I mean, the Fourth is so complicated, has so many exceptions, has so many offshoots. And so I think just practically, it's harder to screw around with the Sixth Amendment.
That's a great point. So Brandon, let me ask you, let's talk about the Gorsuch, because this case was written by Gorsuch for the majority. And for your case in the Supreme Court in Davis, I believe he was also the author of the opinion. So now with RBG's departure and everybody trying to look at those conservatives and wonder, who is the new hope? Who I can get if I go there and to put it into my side to have a good opinion. Do you think Gorsuch is the way to go for criminal issues?
I do. In my case, I identified Gorsuch as the likely swing vote very early. You can see here I have a picture of him and Justice Kagan on the wall, largely because I treat them as the two best writers, and I teach legal writing, so I do that for my students. Gorsuch is idiosyncratic, and when you practice criminal defense, idiosyncratic is good. Scalia was idiosyncratic. We like that. We don't like this same traditional conservative views of law and order that you get from, say, Justice Alito, and we may talk about him later. I think Justice Gorsuch is willing to take a fresh look at everything. Mm-hmm. Sometimes that's going to be very, very frustrating, really frustrating, and sometimes he's going to surprise you. I think Justice Kavanaugh will surprise us in the future, and I'm a minority of view among some of my friends in that. But Gorsuch is the one that I'm keeping my eye on that's most interesting to me, in a similar vein that Scalia was interesting, but perhaps Justice Gorsuch is more interesting. And he gives me some optimism about Justice Barrett, who I think has a similar view, but time will tell.
So, Joe, who is the lost hope in the Supreme Court right now? That you go there if you are defending a defendant, that some justice that you just, oh, don't even bother to try to pull them in. Is that Thomas? Is Alito? What do you think?
Yes.
That's a short.
I think you should assume that if you're going to get Alito's vote, that you'll get them all. It's very helpful if you're an advocate to engage with the views, because you're going to hear from him at argument or at conference, whatever magic happens behind the scenes, and whatever the best argument is, he'll probably think of it. And so you want to. It's a good idea to engage with his views and try to answer them. But you should. It does appear to be a lost vote. Thomas is I think being very interesting. I think that it used to be like when I began practice in the late Rehnquist court. I feel like there were two paths for criminal defendants to get to 5 votes, two sort of models, and one was Apprendi to try to combine the left and the right: Scalia, Thomas, Souter, Ginsburg, and Scalia, Thomas, Ginsburg, and Souter and Stevens. And the other one was to add the liberals and then try to get a vote on the center. And the Thomas used to be a part of the Apprendi coalition, used to be a part of the coalition of the liberal and conservative justices that you could sometimes hope to get to 5 justices on, particularly in Sixth Amendment issues, but also in some Fourth Amendment issues. You might see it in Arizona versus Gantt. You might see it in contested confrontation issues. And I think that Thomas has increasingly started to defect from that coalition, if you can even call it a coalition anymore. That increasingly you see him supply the 5th vote to the prosecution in cases that you might have hoped for, like pretty good cases of statutory construction. I can think of Stoeckling versus United States, where he is increasingly a difficult vote, and his views are, if you're looking for an idiosyncratic view of the law, Thomas has some very extremely idiosyncratic views of the law that don't seem to be joined by anyone. Like in Ramos, we noticed that he rejected the idea that the Bill of Rights is incorporated through the 14th Amendment or through the Due Process Clause, but rather through privileges and immunities. So maybe there'll be some case where that goes in our favor, but in a lot of cases it just means it's more radical even than the votes that we're starting out losing.
Yeah, I vaguely remember recently, I think maybe last year, he also wrote an opinion saying that substantive due process doesn't really exist. That's not a real thing. So Tracy, what do you think?
Yeah, I think Gorsuch is probably our best hope. I'm a little bit biased here. I clerked on the 10th Circuit, and my judge sat on a number of panels with Gorsuch. And he always struck me as very intelligent. He's an incredible writer. But more than that, he's always struck me as very independent. He doesn't strike me as an ideologue. And we've already gotten some really surprising opinions from him. We were talking before this started about McGirt, which isn't a criminal law case, but is a very progressive opinion that vindicates the rights of Indigenous peoples in a really moving way. My husband is an Indigenous rights expert and was moved to tears by Gorsuch's opinion in that case. So I absolutely agree with Brandon that Gorsuch is our best hope. I have written off Justice Thomas and Justice Alito. I don't know that I ever had confidence in them, but yeah, I'm hopeful that Gorsuch will represent sort of the new center of the court.
Okay. The next case I would like to discuss is Collar versus Kansas. It's a due process case. So Kagan wrote for the majority and concluding that due process does not require acquittal of mentally ill defendants who cannot distinguish right from wrong. So Brandon, let's talk about the Kagan. Kagan was really in dissent with Alito and Roberts in Ramos, and in this case, she's forming a 6-3 with conservative again. So what is your general idea about Kagan? What is her take on criminal law issues?
Well, I think of Justice Kagan as kind of, if Justice Roberts is moderate right, Justice Kagan is kind of the mirror image of that, moderate left. I view her as probably the most intelligent member of the court. She's done some incredible work on some very technical, detailed issues in federal sentencing law. But she's not someone that you can count on as a person who represents criminal defendants. She's going to be willing to, join an Alito dissent in part in Ramos, for example. And she's written some other, opinions that have not been favorable to us. But she's a person that's independent, and that's what we want at the end of the day. We wish we had 9 independently minded people who are really going to give a fresh look to everything. She's one of them, and I don't fault her for that. She's always a gettable vote if you make the best argument, and you can always persuade her. And that's all I ask for. So I have a lot of respect for her, even though, she's not going to be consistently for a criminal defendant.
So Joe, I think the question I want to ask you is, when I read this opinion, I have some sort of a confusion kind of hanging around in my head. It's more like, why is this case is even there when there is really no circuit split? And why Kagan ruled the way she wrote in this case? Tell us more about this case.
Yeah, so in this case, Kansas had a statute that said you can use evidence of mental illness to defeat the mens rea of your statute of conviction, but you can't use it otherwise as an affirmative defense. It can be considered again at sentencing, and that might even lead to a hospitalization rather than imprisonment. But as an affirmative defense that defeats liability independent of the elements, it cannot be used to establish a defense merely because the defendant couldn't tell the difference between right and wrong. That was billed as part of a circuit split about whether the Constitution requires an insanity defense in any case. And it was Jeff Green in the Northwestern litigation clinic that we've worked with before. It was a very effective cert petition writing to bill it that way and to hook it into a circuit split or not a circuit split, a state Supreme Court split about that issue, about the constitutional issue. But ultimately, I think the court took it for that reason and then ultimately decided that question was not quite presented here, because they thought what Kansas permitted you to do in terms of having the case, being able to use evidence of mental illness to contest an element and have it be able to be considered at sentencing was something short of the complete abolition of the insanity defense. And so I think that's why the case was there. As far as what Justice Kagan is doing in that case, she's not supplying the fifth vote, interestingly, and she's writing for a majority. She's holding together, 5 justices, you might say, to her right in the traditional liberal conservative lineup. And I think there might be some evidence or some argument, we'll never know, but that some of the argument is written strategically, because I think you could, if you explain that the case fully, argue that Kaler supports the notion that there is a right to an insanity defense of some kind, but that because it was clear at common law that almost everybody recognized that evidence of mental illness could defeat criminal liability. And what she then authored the opinion to say is, it's just that the Constitution doesn't tell you precisely what the components of that that defense might be. That one state might say that it means that you're not guilty if you have an uncontrollable impulse to commit the crime, and another one say if you can't distinguish right from wrong, and another one say the defense consists of not knowing the nature of what you're doing, and another one saying it defeats the mens rea. And none of those tests are constitutionally required, but that it is arguable, I think, from reading Kyler as a whole and reading her analysis of the common law of insanity defense, of the insanity defense and the insanity defense at founding, that the Constitution does not permit states to abolish it completely.
Tracy, what do you think about this case, and what's your general idea about Kagan?
Yeah, I mean, I'm just of the view that we have no meaningful insanity defense at all in the United States, and that our jurisprudence has become irretrievably terrible. For some reason, there's still in sort of public consciousness remains this notion that all kinds of people are, walking free because they fake mental illness. I mean, it just is so far from the truth. I mean, the truth of the matter is it's nearly impossible to win an insanity defense. And yet there are so many cases where people are very clearly so mentally ill they couldn't possibly, under any reasonable understanding of the term mens rea, have formed the requisite mens rea in a case. And so, every time I sit down and read pretty much any insanity case in this country, I'm just so incredibly depressed. And this one didn't give me much hope either. I agree with Brandon about Justice Kagan. She reminds me a little bit of Justice Breyer in the criminal context. Justice Breyer. He's not a super reliable vote either all the time in criminal cases. I think the difference with Kagan is I think she's a little bit more independently minded. I think she's a little bit less pro-law enforcement than Justice Breyer is. But I remain hopeful, as Brandon does, that we're going to continue to see good, thoughtful work from Justice Kagan in this arena.
Thank you. So next, let's move on to some cases that's being up for this term. First one I would like to talk about Jones versus Mississippi. It's a 8th Amendment case that requires the sentencing authority to make affirmative finding about a juvenile's mental state. So this case, Joe, how about you tell us something about this case? I think they just have the oral argument, I think, last week.
Yeah, this case is the third or fourth in a line of cases about juvenile life imprisonment without parole, which might be the saddest 4 words put together I can imagine. There was a Miller versus Alabama. It's really hard to understand the case without going a little bit into the cases that preceded it. Miller versus Alabama was a case that said, and sort of analogized to the death penalty, and said juvenile LWOP, life without parole, is a lot like the death penalty in its irrevocability and its harshness. And so they kind of analogized to some of the 8th Amendment case law that had governed in the death penalty context, and said that juvenile life without parole cannot be mandatory. That sentencers have to have some consideration of the defendant's youth and must have the opportunity to avoid that sentence in each case. And then the next case that came on the heels of that was Montgomery versus Louisiana, which really explains what Jones is about, which is a case about whether Miller versus Alabama was retroactive. And Montgomery involved a 69-year-old defendant who had been sentenced to juvenile life without parole, 50 years ago, or more than 50 years ago, and was now arguing that Miller versus Alabama invalidated his sentence. And they had to decide, is this merely a procedural rule that can be denied to all defendants who have already been convicted at the time that Miller was announced, or is it a substantive rule? And so, somewhat surprisingly, Justice Kennedy said this is a substantive rule because it provides it makes a certain class of punishment, which is juvenile life without parole, categorically unavailable, not to all juveniles, but to at least those juveniles who are not permanently incorrigible. So now Jones, a child, steps onto that train and says, well, if Montgomery is true, and there has to be a fine that it is categorically unavailable for anybody who is not permanently incorrigible, then there has to be some court that finds in a particular case whether or not I am permanently incorrigible. And it's not enough merely to consider my youth and have the option to give me something less than life without parole. You have to decide whether I'm in this class of people for whom this punishment is categorically unavailable. And to do that, we need some finding and not mere consideration that I am permanently incorrigible. And so I think their argument from precedent is very strong, that Jones's is, but the changes in the composition to the court since then, since Montgomery, really pose a lot of challenges in the case, because the dissents in Miller and Montgomery were bitter, to say the least. And so I don't think you're going to get a lot of justices switching sides merely because, well, this is precedent, this is the law now.
So Brandon, let me ask you this question. I listened to the oral argument. I found DOJ is actually in this case as well. Like, what is the federal government interest in juvenile LWOP, which is, in my opinion, extremely depressing? So why is that?
Well, that's a good question. I would ask that question about a lot of cases that we've seen in the last year. What is the Department of Justice doing getting involved, defending a personal lawsuit against the president, or doing all of these things? The only thing I can think of is, Joel mentioned there's an analogy that's easy to reach between juvenile life without parole and the death penalty. And so, obviously this Attorney General is pushing through death penalty cases, like it's going out of style. And, they worried about perhaps some law in that area, some holding that could weaken that. It's speculation to me. I simply don't know the answer. And I do find it bizarre, when you have the, Attorney General of Mississippi getting up there arguing, okay, I get it. What's the Department of Justice doing there? I have no idea. So
I think it's significant in that they did not participate in Miller versus Alabama. So in the Obama's Department of Justice had nothing to say about juvenile LWOP 8 years ago. And when the question was the substantive question of whether mandatory LWOP was available at all, and now with this third order little procedural curlicue on this case, they're here to tell you, that it's fine.
Tracy, what do you think, or what is your general idea about juvenile LWOP in general? I think, are we the only or the very few developed country that have juvenile LWOP in the world?
We're absolutely the only developed country. I think last time I checked, it was something like us and Somalia. I think we're the only two countries worldwide. I haven't looked recently, but we're not in good company. I can say that with great certainty. I too am baffled and depressed that the DOJ has taken this up. I, like Brandon, have no insight into this other than that this is a newer, more brutal DOJ under this particular administration. I think these cases are interesting. Anything that, involves the Eighth Amendment requires a look at an evolving standard of decency. And that notion is such an anathema to originalists, right? I mean, just the idea that the Constitution might evolve over time and require some sort of new ruling on something is so difficult, right, from that point of view. And so I think it puts conservatives in a real bind. If you want to follow the precedent, you've got to apply an evolving standard of decency, but I think probably they're worried about what that looks like for other constitutional provisions as well. Like everybody else who has a heart, I hope this is something that goes out of practice as quickly as possible, although I don't think we're anywhere close to that happening.
So Brandon, let me ask you, that point Tracy just made lead to this question is like why the Eighth Amendment argument is so hard in front of originalists. Is this really because, when we talk about cruelty and we have to really talk about our change of standard from, 200-300 years ago, we have to talk about we're more forgiving than before. We'll have to talk about, we're probably more lovable really to, juvenile minors and then, or our general ideas towards people of color.
As originalists seek to interpret the Constitution in accordance with the original public meaning of those terms at the time. We did really, really awful things to people at the time the Constitution was drafted, at the time the Bill of Rights were ratified. Thank goodness we live when we live now. But, you know, I've seen 1,000 interviews or everyone on YouTube with Justice Scalia, and he talks about this every time. Cruel and unusual has to mean something, right? We all agree with that. But to an originalist, it has to mean what it meant in 1787 or 1860, whatever, with the 14th Amendment. And at that time, we did a lot of cruel and unusual things. So, you know, and Justice Breyer in his public comments would say, they didn't define what those things were. They just gave us the principles. And evolving standards of decency change meaning of principles. So you're not going to ever get through to an originalist ever on Eighth Amendment issues because of how awful things were in 1787 or whatever time period we're looking at. And that's a bizarre reality that we're faced with here. And I have nothing good to say about that. Originalism has its merits in some sense. It's principled, I guess. But when it comes to the Eighth Amendment, it gets really gross in my view.
Joe, what do you think? I think, you know, if I remember correctly, a couple of terms ago, even the New Hope, Gorsuch wrote an opinion about the death penalty. Basically, he said, I've heard enough about the Eighth Amendment and the death penalty. It is okay to have death penalty under the Eighth Amendment. So what do you think?
Yeah, I think that this is an area where we're likely to see some retrenchment. I will say, Justice Roberts, although he dissented in the follow-up or the prior cases about juvenile LWOP, he has not joined the dissent that says that the Eighth Amendment covers only the method of punishment, that it has nothing to say about the proportionality of the punishment to the offense. And so, you know, that might mean something. That might mean this might be the kind of case where he acts as an institutionalist and attempts to salvage the precedent thus far. You know, he's going to have to bring another vote on for that. In order to do that, we'll see whether he can do that and whether he's motivated to. But I think there is possibly some hope that we will not see retrenchment of the precedents that we have already established in the very near term, although there's certainly a risk of that. But I would say putting together the old path that we had in the late Rehnquist court of 4 liberals plus Kennedy or O'Connor, that's not available anymore.
So Tracy, let me ask you this. I listened to oral argument, and I think this oral argument is one of the very first oral argument for Justice Amy Barrett. And she made a really interesting point. Her point is like, why, she asked a question to the petitioner that why is your claim is so narrow that I don't really hear a lot of things about the Eighth Amendment. And so do you think that is a good sign that maybe the new justice is going to be a little bit open-minded about this issue?
Hope so. But she has such a limited body of work, right? I mean, she was a judge for such a short period of time before being promoted to the Supreme Court that it's really hard to tell. We looked at some of her cases prior to this event, and Brandon identified, I think, one Eighth Amendment case, McCottrell versus White, that she's written. I hope that that's kind of the signal that she's open to ruling on this case on Eighth Amendment grounds. I just don't think we have the information we need to know for certain. But man, I'm optimistic. That's what's getting me through the day.
Brandon, what do you think?
I mean, I share Tracy's optimism, you know, but I do keep coming back to, you know, her academic work is largely based on statutory textualism, constitutional originalism. I can't see her deviating on Eighth Amendment grounds from some of those assumptions. So we'll see.
Yeah.
So Joe, what do you think? Are you optimistic when it comes to the new justice, or you are kind of on the fence right now?
I think there's almost no way to know what her Eighth Amendment views are without guessing or using sources that are not that probative. I have to say I reviewed all of her Seventh Circuit opinions in which there was a concurrence or dissent, which, as Tracy says, is not a lot, because that's how we pick Supreme Court justices these days, is we protect them from records, from having a record. But it isn't the very worst I've ever seen. There are a few glimmers of hope. There are concurrences in which she, from a criminal defense standpoint, of course, that there are glimmers of hope in which she, seems to have a view of the facts in Fourth Amendment cases that support a sort of robust Fourth Amendment idea of the Fourth Amendment, and there is some signs that she can be led to conclusions about that benefit criminal defendants or others involved in the criminal justice system on the basis of just following the text of a statute. But I would not say that I have as much hope for her as I have for, say, Gorsuch, who has not merely, the same pedigree that Scalia has of taking an originalist framework and following it to where it goes, even if it benefits a criminal defendant, but also has expressed an affirmative appreciation of the weight of putting somebody in prison and what a heavy, what a momentous act that is and should be, and how important human liberty is in that circumstance. There is very little sign of that in Justice Barrett's Seventh Circuit writings. If you look at her work on mandatory minimums, dissents and concurrences where she's disagreeing with panels of the court in order to lock people up longer on disputed claims of mandatory minimums.
Thank you. So the last question I would like to talk about is Torres. It's Torres with Madrid. I think this is a Fourth Amendment case, very kind of a classic Fourth Amendment issue. It's about whether an unsuccessful attempt to detain a suspect by use of physical force is a seizure. So let me ask you this, Tracy. So the new justice, she used to be a clerk for Scalia. And Scalia, in my opinion, he can be really friendly on the Fourth Amendment cases, not all the time. Do you think she will follow her old boss footprint on those issues based on Fourth Amendment?
I hope so. I think what's really interesting about Torres is that it implicates a case, a 1991 case called Hodari, which Scalia authored majority opinion in. And in Hodari, a suspect had not been seized physically when he threw contraband. And so the sort of ruling was that the Fourth Amendment didn't apply at the moment that he threw the drugs because the police had not yet applied physical force to him. And what's interesting about Hodari is that Scalia uses a very originalist interpretation of the word seizure. Scalia says that a bodily intrusion is the classic form of a seizure. That seizure involves the laying on of hands on a suspect. And that's what it's always meant. That's what it's intended to mean in the context of the Fourth Amendment. In this case, police shot somebody. He wasn't even really a suspect at that point. The police approached a vehicle. The woman in the driver's seat thought she was about to be carjacked. And so she drove off and police turned and shot her twice. She got away and then subsequently checked herself into a hospital and was then arrested. She was the one that turned around and sued the police for violation of her civil rights. And one of her arguments is, you seized me when you shot me. And so a Fourth Amendment analysis needs to come to bear in this case. And what the government has said in response is, we didn't seize you. But we have this really conservative originalist opinion from Scalia that would suggest that when the police applied force, that they absolutely seized this woman. And so if, in fact, Justice Barrett does choose to follow Justice Scalia's originalist interpretation of the Fourth Amendment, that would suggest ruling against law enforcement in this particular case.
Brandon, what do you think?
I think Tracy's absolutely right. I think Hidari already answers the question. It's simply a question of whether they follow it. Justice Scalia in Hidari said that Fourth Amendment seizure is coextensive with the common law of arrest. And that includes either the person saying, I give up, you got me, or the application of physical force. When you shoot someone, no question, physical force. If they just follow Hidari, I think it's fairly predictable. And I think it's a good decision, particularly for 1983 civil rights violation suits. So I feel good about Barrett being on the court on this case.
I do too.
Joe, what do you think? Do you think her recent writing in the Seventh Circuit on similar issues sort of shed some light and hopes on her for the Fourth Amendment issues?
Yeah, I mean, there are definitely causes for hope there. There's a couple of cases in which she either found a Fourth Amendment violation in cases where it was contested, or concurred specifically to say, she had a narrower view of what the officers could do in the situation than the majority did. It is a little bit, I mean, it's like everything else. It's a slender read to figure out what her view is here, because we're only talking about 2 or 3 cases. And we're really talking about real fact-bound cases that she was deciding in the Seventh Circuit that don't really give a lot of insight into the bigger legal questions that may be before the court in that case. But I listened to Torres, to the argument in Torres, and had the same optimism that I think my co-panelists had on that case in particular. One area where I feel like I'm kind of pessimistic in the Fourth Amendment is I think we're sort of getting to the point where the substantive scope of the Fourth Amendment, what police are actually allowed to do, is narrowing, or we're getting firmer limits on it, but the remedies are getting harder and harder to access, that the exclusionary rule is getting harder to access, and qualified immunity, at least in the circuits, is getting harder and harder to overcome. And so we're going to have a sort of a Soviet constitution that says we have all of these rights and no right to enforce them.
Yeah. Well, it might sound weird, but to some extent, we want our new justice to be a Scalia, at least on some sort of cases. So I think next question is also sort of an answer to one of the questions we got is, let's talk about the robbers. I think, I asked this question to a lot of people from different bars, Wall Street Journal or WAPO have written a lot of opinions about, Roberts is probably the real pillar right now to the Supreme Court. He's going to be responsible to trying to maintain the integrity of the court by forming some opinions to debunk the idea that, now the Supreme Court is so political and everything is predictable just based on party line. But do you think criminal law issues is the issue that he's going to actually go ahead and do it to surprise people to say that, see, you cannot predict the Supreme Court? I'll start with Tracy.
I hope so, but I'm not super optimistic. Brandon and I have debated this point on a number of occasions, and not to steal his thunder, but I think he makes a good point, which is that I think Roberts is more inclined to do this when people are watching. So, if it's a big LGBT case, if it's a big immigration case, I think criminal law cases and criminal justice or criminal procedure cases are incredibly important. I think they deserve far more attention than they get because they implicate the rights of so many Americans. But they're usually not high profile cases, unfortunately. And so if Brandon's right, that would suggest that Roberts is not going to lead the court to do, surprising things in criminal cases. I hope that that's not true. I do have the sense that Roberts very much wants to protect the integrity of the court, even when the court is not, operating in a high profile situation. So again, I'm telling myself lots of hopeful things just to get through the day. And so I'm telling myself that justice is our great hope here. But I worry very much that Brandon is right.
So Brandon, so you are obviously not optimistic when it comes to Roberts. Tell us why.
Well, Tracy was telling me kind of my point. I'll shed some light on Tracy's side, which is that Roberts is an institutionalist who cares about the integrity of the court. That's that's also true. My concern now is even further is that to what extent does he have control over the court? You need 4 justices to grant cert. You need 5 to write a majority opinion. He doesn't need to be in any of those for kind of a further right or more conservative or more law and order opinion to be written. Right now, Justice Kavanaugh is the ideological center of the court. So we've gone from Kennedy to Roberts, who only had it for a little while, really. Before Kennedy, it was probably Sandra Day O'Connor. And now it's Justice Kavanaugh. I mean, Roberts can try to exert whatever control he can by doing like what he did in June Medical Services, but they can move without him, and so we'll see what happens.
So Joe, I think what Tracy talked about draw to another question is how much social movement has an impact to the court, because I think it's undeniable that a justice would more prone to resolve some issues in certain way if people are allowed. What do you think?
Yeah, I think there's no question that the court, that there's an interaction between social movements, cultural change, and the court. It's just always it's so many different kinds of ways that they can interact that it's difficult to to speak about that in simple terms. I mean, I think that one sort of way that can happen is that if there's if you look at the LGBT movement, I think that you can make a pretty persuasive case that cultural change itself produced Obergefell, but it wasn't. I don't know that it was really focused on the Supreme Court. That the gay rights movement wasn't really focused on the Supreme Court before it got Obergefell. And then there's other kinds of social movements, like you would say the anti-abortion movement, in which the securing a vote to overturn Roe was an actual focus of the Supreme Court. I think that if current movements, and there are a lot of them to reduce mass incarceration, are going to affect how the Supreme Court rules, it will have to be sort of more through the Obergefell model of cultural change, because it's difficult. There's not one single focal point for that. But the good news is, I think that, even as the news in the Supreme Court, I think, is overwhelming, is generally bad. We can look for glimmers of hope and paths and strategies, but generally it's going to be an area of retrenchment in the area of criminal defendants' rights. But the Supreme Court is not the only lawmaking institution in the country. There are state legislatures, there are district attorneys, and there's Congress, and all of them have been influenced by movements for reduced mass incarceration in recent years. And we shouldn't give up hope just because one institution is turning away from us.
My last question goes to Tracy. So tell us more about technology in the Fourth Amendment. Do you think there are going to be a lot of interesting cases coming up to the court? What happened if, say, a police officer pull over a driverless car and things like that?
Yeah, these are the cases I'm really excited about. I think the Fourth Amendment is super interesting right now because we've had two very distinct regimes. We had sort of the period of time pre-1960 where Fourth Amendment jurisprudence was, based on the notion of trespass and of physical invasion. And that changed with Katz in the 1960s, and reasonable expectation of privacy became the sort of dominant inquiry. Neither of those regimes works well in a world with cloud computing, right? Or in a world in which we have driverless cars on our highways or drones in the air. And I like this issue because so far it's remained fairly apolitical. And we've seen the court really struggling to figure out collectively how to think about Fourth Amendment rights in this new world that's changing incredibly rapidly. We've seen some good opinions from Justice Roberts, and we've seen, I think, the court working together to try to reconceptualize how we're going to deal with all these cases. So, very soon we're going to have a case in which a drug dealer fills a trunk with 500 pounds of heroin and then has that car drive unoccupied across the country. And the question then is, do the police get to pull it over because the Fourth Amendment applies to people and not places, and we don't have a person in the car, and so there's kind of free reign to pull it over? Presumably not. On the other hand, right, is it the case that police need probable cause to pull over something that doesn't even have a human in it? Almost certainly not as well. And so I'm starting a line of papers thinking through, what the sort of rational response to aerial drones and driverless cars are in the Fourth Amendment context. I don't have any magical ideas yet. Nobody does. But I'm really excited to see how the Fourth Amendment changes in the next 10 to 20 years.
That's all very exciting. And I think we're running out of time. We have time to answer one question. The question is military courts. Military courts do not require a unanimous jury. Do you think Ramos will change that as a result? Brandon, what do you think?
Well, and I didn't know that about military courts. And I think it would come down to simply what extent the Sixth Amendment applies in the context of military tribunals. What is the sovereign, for example, through which they derive their authority? Is it all rules-based, or is it based on some of these other principles? And I just don't know the answer. I know kind of the fight right now we're having is in the revocation sentencing context. To what extent can we incorporate the Sixth Amendment? And the Supreme Court in the past has said the Sixth Amendment doesn't apply to revocation. We see some movement there. So the fact is, the Sixth Amendment does not apply in all contexts in which a defendant is being sentenced to a term of imprisonment. That's a fight that we're having. Let's keep moving in that direction. But I just don't know enough about military court to be able to speak in any more detail on that.
Thank you. Well, it's past time. I want to thank you again for everybody who joined us today, and especially to our panelists who give us such a great insight about those Supreme Court cases.